Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thank you for joining us. Listen to our ongoing little series of videos related to taking this long, convoluted set of laws that we call our self-defense laws, trying to break it down in easy to digest forms for all of us lawful and responsible gun owners to understand. I thought we'd take a couple minutes today and talk about the importance of Washington's self-defense reimbursement laws. Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button down below. If you want to stay up to date on all issues related to your Second Amendment rights, both on a statewide and nationwide level, go ahead and click the subscribe button down below. If you click the little bell logo down below, you'll be notified when we post new videos. And most importantly, let's keep the comments rolling, because those comments is how the algorithm with YouTube gets our video out to more lawful and responsible gun owners like you. That's the online community that we're trying to build. So, in this series of short videos, we've been talking about the laws of self-defense. We talked about the general laws of self-defense, when we can use deadly force in self-defense, what can be used and what can't be used in the defense of property versus the defense of people. And today I want to talk to you about something that's very unique to Washington law, and a reason why having a very valid self-defense claim can go a lot further than one might imagine. Now, to understand what a self-defense claim is, a self-defense claim is essentially an affirmative defense. What an affirmative defense is the defendant essentially says, yes, I committed the act. In this case, it would be the act of assaulting another person, inflicting force upon another person. However, I did that act with lawful justification. And in the case of self-defense, I was threatened with some sort of imminent threat, whether it was to an injury to me, serious bodily injury, potential death, a felony upon my person or somebody in my presence, and then I found that I needed to use force, that it was necessary, that it was reasonable, and that it was proportional. If an individual raises a self-defense claim at trial, it actually shifts the burden of proof onto the defense. Normally, the defense does not have a burden of proof at all. The proof is beyond a reasonable doubt. It must be established by the prosecution. The defense starts as presumed innocent and shall remain presumed innocent until and only until the prosecution overcomes their burden of proof. However, when we raise affirmative defenses, yes, I did it, but I had a lawful justification, now the law allows a shifting of burden. That is, the defendant must prove something. In the case of self-defense, they must prove by preponderance of evidence, slightly more likely than not, that the use of force was necessary, reasonable, and proportional. And if they are successful at establishing by preponderance of evidence that self-defense was necessary, reasonable, and proportional, then it becomes the prosecution's job to disprove that beyond a reasonable doubt. And if they fail to disprove it beyond a reasonable doubt, the jury will be instructed that they shall return a verdict of not guilty by reason of self-defense. Now, what prosecutors have a tendency to pucker up about is RCW 9A.16.110, because in Washington State we have some very unique laws. So let's take a look at what that statute says. RCW 9A.16.110 subsection 1 says that no person in the state shall be placed in legal jeopardy of any kind whatsoever for protecting by any reasonable means necessary himself or herself, his or her family, or his or her real or personal property, or for coming to the aid of another who is in imminent danger of or the victim of an assault, robbery, kidnapping, arson, burglary, rape, murder, or any other violent crime as defined in RCW 9.94A.030. And that statute that they reference at the end lists all violent offenses. You can look the statute up for yourself. We'll put the link down below for you. But obviously, it doesn't take a very vivid imagination to determine what are considered violent offenses in the state of Washington. Now, that's subsection 1 of 9A.16.110, but it says in there specifically that no person shall be placed in any legal jeopardy whatsoever. Now, think about this. Think about the individual who has absolute righteous justification to defend themselves. They inflict force upon another, completely justified in doing so, but ultimately end up getting charged with an assault. And in some instances, if it's a felony assault, we're not looking at $5,000 or $10,000 in legal fees. We're looking at $50,000 to $100,000 in legal fees. What happens if when that person is found not guilty by reason of self-defense, but half of their family fortune has been spent to get a verdict that they were lawfully entitled to? Well, that's where RCW 9A.16.110 subsection 2 kicks in, and it reads as follows. When a person charged with a crime listed in subsection 1 of this section is found not guilty by reason of self-defense, the state of Washington shall reimburse the defendant for all reasonable costs, including the loss of time, legal fees incurred, and other expenses involved in his or her defense. To award these reasonable costs, the trier of fact must find that the defendant's claim of self-defense was sustained by a preponderance of the evidence. If the trier of fact makes a determination of self-defense, the judge shall determine the amount of the award. What does this all mean? If a defendant successfully defends themselves by way of self-defense, if a jury finds them not guilty by reason of self-defense, the defendant is entitled to reimbursement of all costs necessary to defend them, not just legal fees, but as it says in here, including the loss of time and any other reasonable expenses. So you're looking at legal fees, travel fees, all the wages that you lost when you were missing work, any experts or reports that had to be prepared in order to properly litigate your case. Even a misdemeanor assault can easily rack up $10,000 to $15,000 in charges. A felony assault can easily exceed $100,000 to $200,000. So yes, the existence of RCW 9A.16.110, particularly subsection 2, makes prosecutors very leery about moving forward on cases where there is a valid self-defense claim. The defense only has a burden to establish the possibility of a self-defense claim by preponderance of evidence, and they shall prevail unless the prosecution can disprove it beyond a reasonable doubt. And that is a lofty burden to meet in many instances. So at the end of the day, in summary, the importance of having a valid self-defense claim, the importance of getting an attorney on board immediately after the incident, to get an investigator on board, to conduct interviews, to take photographs of the scene, to do whatever is necessary to make that self-defense claim airtight is essential to your defense. Listen, you may have more questions about the Washington self-defense reimbursement law or anything related to your right of self-defense or your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com. Or, of course, you can call us directly at 425-765-0487. Listen, part of being the lawful and responsible gun owner, like we talk about here all the time at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.